today to have with us Superior Court Judge Bernard Veljacic. He'll be talking about Superior Court proceedings. We also have Superior Court Commissioner Stephanie Ellis. She'll be talking about family court and the dependency docket. We also have District Court Judge Kristen Parcher, where they've already been using Zoom, so she can give an overview of the current proceedings, as well as some do's and don'ts for how Zoom is working in the courtroom. And finally, we have attorney Marina Spencer. She's with Vancouver Defenders, and she's going to give some practical tips for attorneys on how to appear in court using Zoom. Before we get started, just some housekeeping measures. First of all, if you haven't done so already, you might want to make sure your microphone is muted and your video is off, because otherwise everybody will hear you and see you. Also, I want to make sure you knew that we do have an opportunity for questions at the end. So our presenters will be available to ask questions. The way you ask a question is use the chat function on your Zoom presentation. That chat will go to Lisa Darko with the Clark County Bar Association, and then she'll forward your chat, your question, to the presenter. Please indicate in your chat which judge or presenter you would like to have your question directed to. Also, today we're going to be trying to get CLE credits for these. So if you weren't able to actually register for the CLE, please email or use the chat function to send your name and your bar number to Lisa so that she can make sure you get credits. She will also be sending out a link for a SurveyMonkey so that you can rate the CLE, which really helps the Bar Association. I think those are sort of the housekeeping measures. Oh, one more tip. If you look in the upper right-hand corner of your Zoom platform, you'll see some options on how to see this presentation. I recommend you use the speaker view as opposed to the gallery view. That way you can actually have a full screen of the person who is talking as opposed to a gallery view of everyone who's on this call. My understanding is we have quite a few people on the call, so definitely want to switch to that speaker view. Okay, with that, I'd like to invite Judge Veljacic to get us started. I believe he's going to start with an update on how Superior Court proceedings are going right now.
Yes, thank you, Emily. Thanks everyone for being here. We're currently using Zoom. In fact, I had what I would call my first successful Zoom docket this morning, a criminal docket, where very few things went wrong and it mostly went right. That's after using Zoom a few times already. So we soldiered through it. We've been working out the kinks. We even used a breakout room. So we are currently trying to do all things via Zoom as a preference. And so I'll tell you a little bit about why we do that. We've got our governor's orders, the executive orders, a series of Supreme Court orders, and our local orders that really reflect those actions by the higher up entities. We have to comply with social distancing requirements throughout the courthouse, not just in the courtrooms, but also in the common areas. And so it's necessary to limit the number of persons showing up. Therefore, remote is available. Now the courtroom is still, the courthouse and courtrooms are still open because we have an open courts doctrine. And so we've gone through and reviewed everything that we do as a court and decided on what we have to do and what can be done most efficiently with remote appearances. And so in minimizing folks here, we've got remote participation for telephonic and video hearings by the litigants, and in some cases on family law or bench trials, and in particular we see more bench trials in the civil arena. Witnesses are also in, if the parties are in agreement and the judge orders it, we can have witnesses appear remotely. We've started in Zoom a little bit last week, and we're, as of this week, 100% Zoom. We've gone away from WebEx, which is telephonic only. There's been some discussion about or some questioning about when or how we're going to start trials. That's not going to occur based on the Supreme Court order until after July 6th. I'll submit to you that's not going to be the start date. What we have is a space crisis. The practical reality is that for most of our trial weeks, we have district court and superior court handling trials at the same time. That's a large number of persons for what has lately become a small jury assembly room when the need to socially distance is taken into account. So let's say we got a serious felony murder case. You'll see 75 jurors, sometimes 100. Well, how do we do that? We're looking, that's not even counting the district court jurors that need to come in. So we're looking at various locations, one of which is the fairgrounds. The rental there is about $7,500 a week for the cleaning that's required. There's security aspects that need to be looked at. They're being looked at. That's one of the space issues, is just jury selection at a remote location. So then we're not bringing all those people to the courthouse. There becomes, once that trial begins, once that jury's selected, there's another issue regarding when the parties need to be heard outside the presence of the jury or when the jury needs to deliberate. Our jury rooms are no longer appropriate for that. We anticipate, once we have a jury, seating approximately 3 jurors in the jury box, properly socially distanced, with the remaining jurors out in the gallery. But again, once we need to caucus or be heard outside the presence, we'll need another courtroom. So on your average Superior Court trial week, you've got 5 judges available for trials. We'll need another courtroom for each trial. So of those 5 courtrooms, one trial will take 2, another trial will take 2. We're anticipating the ability to do only 2 jury trials in a week, assuming we can get through these other issues with jury selection. And so the need to comply with the governor's orders, the Supreme Court's orders, has really made it difficult. We feel we're being adaptable in how we do things. We're working daily on how to get through this. So I hope I've covered everything you've anticipated.
So
go ahead.
I'm curious, why did Superior Court and District Court adopt Zoom as the platform for virtual courtroom proceedings?
Well, and I'll really tip my hat to District Court here, and Judge Parcher's online. I want to say thank you to her, who, she was presiding for a while there when this all started. But for some time, District Court has really been on the tip of the spear on these issues because they have the established staff, which Superior Court doesn't have as a result of budget cuts for the last recession. In any event, we worked with them to look at the different platforms where WebEx, Microsoft Teams, and Zoom were all considered. And when you look at some of the features that Zoom has, in particular the option of doing a breakout room where you can have a private conversation. We did it this morning on my docket with an attorney and client outside the hearing and viewing of the rest of the participants. That's a critical function that we thought was necessary. The scheduling aspects of it, it makes a good record, Zoom does, meaning we can, with some additional hardware, run Zoom directly through our JAVS, which is our audio and video recording system in the courts. And so it's a clearer record for later review. Accessibility to users. We have a free app. Now, I know not everybody has a cell phone, let alone a data plan that allows this, but we still have open courts. I had some folks live this morning. About 8 folks showed up, properly socially distanced in the courtroom. But still, this does, for most people, allow them to appear remotely with a free app. outside of the courthouse. Also, Zoom allows the courts control the proceedings. As we see here, we have a waiting room, and then we have the ability to mute. That's a real important aspect of being efficient while on the docket, is not having people who are just joining the call jump in and interrupt things. As it is, video or remote hearings, they just take longer. It's not the same as live face-to-face communication. You lose a lot when you're not present in terms of nonverbal communication. And so for those reasons, we all settled collectively on Zoom. And we really thought with using two court systems, it was really important that we have the one platform. So
I think attorneys would like to get into sort of the procedural aspects, how it actually works to, schedule a hearing, what the hearing format is like for attorneys out there that haven't had one yet. Maybe you could kind of go through that step by step for us.
Well, so I'll say you're doing it right now. First of all, we have, when we're having a court hearing, at least my exposure as the host of the meeting, it's very similar to this, where if we'll call a case, have them unmuted so they can participate, often they unmute themselves. But for scheduling, we're running our dockets currently civil. Let's just put civil aside here. We're running our civil Friday civil dockets as they've been scheduled. We oh gosh, it's been a while now. When this all started, we were doing special sets, but for some time we've had our dockets, and we are doing those remotely. At first it was telephonic only with WebEx, and now it's Zoom. So those are as they were with a remote appearance. Family law, I'll let the commissioner address that later. I'll only say that the judges they're conducting dockets as far as I understand. For criminal matters, and this is where a screen share would be helpful, we have our order that sets out, it's our order 20-06 from Superior Court, sets out at paragraphs H and I what matters we are hearing: arraignments, first appearances, bail review, for example, in particular for in custody. We are holding plea hearings. Out of custody, we've got first appearances, arraignments, and then overall other matters as set by the particular department. So we've got criminal dockets going at 9 a.m. We have first appearance docket, and then a separate judge hearing the criminal docket. Those used to be combined, but now because of the time it takes to do these hearings, we've had two judges doing those dockets, and then Monday through Thursday an out of custody docket. So put them on the docket, cite them on, to come back to the question, cite them on as normal. And if you want a special set, let the department know. There's a limited ability to do special sets because the jail has 8 video rooms that are shared between district and Superior Court. That makes things difficult.
Right. So are matters held sort of in order in which they're like 1 through, or how do you take them on the docket?
Good question. For in custody matters, the jail determines who they can bring over. They've got to keep people separate. They have transport hazards. They all these issues. Sometimes people don't want to wake up to come to court, and so they'll go through and place people in the rooms, and they let us know, and that's the order. On out of custody matters, I've typically called them in order, and I do that on my civil dockets as well. Numerical order, number 1 on the docket, and follow.
What about for exhibits? Let's say if you are doing a bench trial, how is that going to work?
We've looked at a couple different options. Judge Vanderwood and I are on a subcommittee where we've explored Dropbox. We've decided at this point not to go with Dropbox because of issues around who the custodian is, security. Dropbox is encrypted at a SOC 4, I believe is the term, which is high level. Still, what we've decided to do is have an agreed set of exhibits in notebooks, and you see that in family law frequently, as well as other bench trials I've done. You have an agreed set, and everyone gets a notebook, and the witnesses receive the exhibits they'll need to review. I think it's important to keep in mind necessary redactions as you're circulating what can sometimes be sensitive material. But what that allows is for everyone to be looking at the same item without putting it through a Dropbox necessarily. If there's a need, for example, on a cross-examination or a rebuttal case, there's need for an exhibit that wasn't anticipated, as you know, we see this happen. Then certainly things can be presented. I would check with the particular department, but ask how they want to do that. Some might want a thumb drive, some might want an email. And so we can do that and still share screen to show everyone. We just, at this point, don't want the bulk of the materials in that format.
Will attorneys have the option to share the screen, say if they need to present an order for the judge to sign?
Yeah, we can, you know, in particular in a docket setting, we prefer to receive a proposed order ahead of time on the civil dockets. If it's a criminal docket and that's really not the practice, you know, that's one shortly thereafter. In a trial setting, the judge has the option of allowing folks to share screen or not. The reason we control that is because, believe it or not, not everybody is respectful of court. Remember, this is court. And so, you know, people can share all kinds of stuff on not only their screen, but their background, their t-shirt, whatever. And so I won't talk much more about that because that really goes to decorum, which I believe Judge Parcher is going to cover specifically.
Right. Any other suggestions or tips for attorneys? Because I know that every judge might have a different proceeding or a way that they prefer to handle it. Anything else you'd like the attorneys to know?
I'm going to steal a little bit of Judge Parcher's thunder. If you hear somebody online unmuted, I've heard this. When I heard it, I stopped it. We don't always hear it. And I'm talking about they're on the Zoom. We're going through a docket, and they've got a phone call going on with another client on their side. They're giving some really good advice on very, you know, privileged matters. I heard it, and I stopped everything. Said, "Hey, listen, mute the dang thing, would you?" And they did. It was a good-natured ribbing. In any event, if you can hear that and the judge can't, call it to our attention, please. We want to make sure everyone can hear and participate. We have open courts, and we believe that folks should be hearing what's going on. And so that's the one tip. I probably have more, but I'll wait for Judge Parcher's turn.
Great, thank you, Judge Veljacic. Next up, we have Superior Court Commissioner Stephanie Ellis to talk about the family law and dependency docket. Take it away.
Everyone. Thank you, Ms. Sheldrick. So as most of you already know, we did release, I think either late last week or early this week, information that indicated that the family law dockets will be open, the Commissioner of Family Law dockets will be open effective June 1st. So starting next week, that includes the Wednesday morning show cause dockets, the Thursday afternoon mob dockets, and the Wednesday afternoon pro se dockets. Those will be at their regularly scheduled days and times, so 9 a.m. on Wednesday morning, 1:30 for the pro se docket on Wednesday afternoon, and 1:30 on Thursdays for the mob docket. We are limiting the number of hearings that will be held for each docket. They won't be 25-item dockets like we've had in the past. As Judge Veljacic alluded to, these telephonics, even with a very limited argument, just take longer. And so we are going to limit the number of things that the number of items we can hear. Again, this information was disseminated. It's also on the county website. So I'm going to be fairly brief so that we have enough time for Judge Parcher and Marina to go over the tips. But a few things I want you to know. First and foremost, Superior Court is sort of at varying stages of equipment installation to start Zoom. We're not at district court level just yet for immediate implementation. So while dependency has been my guinea pig and I've been able to get on Zoom and have these live feeds, I don't believe the other commissioners are able at this point yet to have the live video feed, although they can still participate either telephonically or through their computer system. So I want you to be aware of that at this time. Starting next week, we might not all be up and running with a full Zoom. That being said, at least for my preference, will be that in the event you are able to appear by video, I would like you to appear by video. It does make the record cleaner. It makes it much easier for me to see what's going on and help understand what people are saying when they're communicating. The other thing I'll say to you is just because you can't see the commissioner doesn't mean they can't see you. If they are logged on their bench computer and you have your video feed up, just because they don't have video feed on them doesn't mean they can't see you eating, drinking, talking on the phone, or otherwise being inappropriate in the background. So please remember that. In terms of how to get on a docket, it's going to look just like it did pre-pandemic. Matters have to be timely filed and served. There is no exceptions. We're not doing away with the local rules in terms of timing. If the docket is closed for that week because it's full, you need to set it over to the next week or to the next available docket. The exceptions to that are going to be the same as it was pre-pandemic. Restraining orders that need to be heard within 14 days can be cited on a closed docket. And if there's an emergent matter that needs a motion in order to shorten time, that goes to the assigned commissioner. And we'll determine at that point whether or not we'll hear it earlier than that on a closed docket. Please contact Ms. Wittenborn via email only. Do not call her. She is being inundated with calls. She is going, starting back to June 1st, she's going to be handling all 4 commissioners, including their attorney dockets and their pro se dockets. That is a lot of people every single week. It is much easier for her to handle things if she is getting that information via email and not via phone. Please don't call her and please be patient with her. Courtesy copies. Traditionally, courtesy copies are required in family law. We don't want your courtesy copies right now. We don't want paper coming from your office to Becca's office and then to our office. We're trying to eliminate the spread of germs if we can. So courtesy copies do not need to be filed, but that just highlights even more so the importance of making sure that your documents are timely filed, because if they are not, they will not be in liberty and the court cannot review them prior to the hearing. Information for remote appearance, again, primarily Zoom, will be available at least 2 days prior to each docket. That's going to come out by most likely by Ms. Wittenborn, although Ms. Freese might also be helping as well. It is your responsibility to make sure that Ms. Wittenborn has your correct email address so that she can get that information to you. You are then welcome to forward that to your clients so that they can log on to the hearing as well. Additionally, if there is a pro se litigant on the other side, it is extremely helpful to the court if you can provide their email address to Ms. Wittenborn so that we can have contact information for that pro se litigant. The clerk's office just doesn't always have that. And if you have that information, that is very helpful. If you cannot appear remotely, as Judge Veljacic indicated, you do have the option for coming into live court. But again, it is extremely difficult with our system right now to social distance everywhere, everyone. So if you can appear remotely, we are asking that you do so, and that is highly preferred. It keeps us safe, it keeps you safe, it keeps the clerk's office safe. In terms of how the docket will be called, the commissioners are in agreement. We intend to call the docket in order. That way, if you know you're on my docket and you're number 1, but you're number 10 on Commissioner Liebman's docket, you're going to call my docket first, and then you're going to go to Commissioner Liebman's docket. We will obviously reserve the right to call quicker matters first, but for the most part, we intend to call this in order. If you are not present when your number is called, you'll move to the end of the docket. Please communicate with opposing party, opposing counsel if you are need to be a few places at once so that we know what's going on. Oral argument is going to be very limited at these hearings, and I'll be the first to say I haven't been good about limiting oral argument, but I've only been hearing 5 or 6 at a time. I'm going to be hearing a lot more than that now, and so at this point, oral argument is going to be limited. We are a pleadings-based practice in family law, and so there shouldn't be a whole lot of need for a lot of additional argument. After the ruling has been made, we're going to stick with the procedure that's already been released regarding entry of orders. We're trying not to clog up our dockets with entry of order hearings. And so what I want to do is have you confer with counsel in terms, or opposing pro se litigant in terms of the orders. And then if you cannot come to an agreement, you would email a copy of the proposed order to Ms. Wittenborn, and the opposing party would email either a redlined copy or a brief summary of what their objections are, and the court will review that and enter the order at a later time, or if needed at that point would set it on for entry of orders hearing. But again, we're trying not to clog up our dockets with those types of hearings. As for the dependency dockets, I'll be really brief here because we have been doing these remote hearings for 4 weeks now. They're getting better and better. But I just do want to let those of you who sort of dabble into a dependency and haven't been a part of those dockets to let you know that I am hearing Tuesday dockets are scheduled as normal. I am hearing shelter care evidentiary hearings by remote capability. I'm also doing fact-finding trials that way in the event those are agreed upon by the parties. I'm not forcing fact-finding trials to be heard remotely because our Supreme Court has indicated there is good cause to set with outside the 75-day time frame. And so unless the parties agree to the hearing it remotely, I am allowing the parties to set out for in-person hearings. So that's it in a nutshell for dependency and for family law. I have asked the dependency folks to be present on the Zoom call today, so I don't want them to feel jilted that I didn't spend a lot of time on that, but primarily I wanted them on the call for the practical aspects that Judge Parcher and Marina are going to be sharing.
Thank you, Commissioner Ellis. That was extremely helpful. Judge Parcher is up next. She's going to talk first about some of the mechanics of Zoom in the courtroom, since District Court has been leading the way and already using Zoom. So Judge Parcher, take it away.
All right, thank you, Ms. Sheldrick and everyone else for being here today. Just a quick overview of what we're doing in District Court. We're in about our 4th week, kind of depending on department, of using Zoom. Just so you're aware, at least on our District Court website, we have some YouTube videos on how to use Zoom that you can refer clients and participants or yourself to. We've got fillable forms for handling electronic paperwork that can be used in criminal matters. We also have a remote hearing handout on our website as well. That's a good, quick, like kind of Apple versus Android, how to get on Zoom, and some troubleshooting facts. Generally, so our scheduling is going by department. We would like folks just to know that our online calendars that are generally posted on our website may not be accurate because every department is just trying to fit in as much as we can. We are anticipating starting to send summons out for virtual hearings in June for all of those hearings that were canceled since March 16th. Generally, I think most departments are setting trials out past September 1st to kind of allow those first trials to be for folks that are in custody. We're trying to do kind of some of the departments anyway, and what I've been doing that's been working really well is doing staggered schedules. One of my concerns with using Zoom is having participants waiting too long in a room, especially someone that might not have the bandwidth or the battery power, those sorts of things. So we're trying to, you'll note on a lot of dockets, we're kind of sending out Zoom invites in staggered blocks. For instance, I might do 8:30, 9, 9:30, 10. Just that we can kind of limit the amount of time that folks are actually waiting for their hearing to happen. If you have paperwork in District Court anyway, so example, like a diversion entry, a change of plea, deferred prosecution entry, those sorts of things, all that paperwork should be reviewed with your client. It should be reviewed, sent to the prosecutor, and then filed and emailed to the judicial assistant for that department so that it's in front of the judge prior to the hearing date. And then the expectation is that you've also have given that to your client as well. So if I'm reviewing a change of plea, they're also reviewing that same document in front of them. So in terms of how the actual mechanics work of a Zoom hearing. So once you've reached out to that department and you've cited a matter in, and again, we're not just filing cites because it's department by department, so you do need to reach out to the judicial assistant first. But the judicial assistant is going to send an invite to the attorneys and to the litigants. So if we have good email, we will actually send an invite directly to defendants as well. When you accept that, so if you have Outlook, for example, you can accept that invite and it can go directly into your calendar depending on your calendaring system, or you can click on the link directly from the email. There is also, you'll notice on all of those invites, it has the meeting number and password, so you can enter that manually as well. So if the link isn't working, or if you're forwarding it to a client and the link's not working, all that information is still on there to hand enter the meeting number and the password if necessary. We have had it come up where an attorney cut and pasted that information to send to a client, and because of that, I think the link didn't work. So just make sure that you're in good communication with their clients. Let them know, hey, if the link doesn't work, there's the information. Just get on early so you can get all of that kind of figured out, so you're in the waiting room when that docket starts. So how it looks is once you, the other thing too, when you sign up for Zoom, just be aware that if you've been using it previously, let's say for a happy hour, and you gave yourself a cute nickname, when you get back into Zoom, it might still use that nickname. So really make sure you rename yourself before getting into that hearing. Once you have logged into a hearing and you're in that waiting room, you do not have the ability to rename yourself. And so you are stuck with your obscure movie reference, your childhood nickname, or even worse, just like your initials, which isn't very helpful to the court when we're trying to decide who's actually logged in and ready for the meeting. So that's a huge thing. Please share it with your clients as they log in as well. Full names and nothing too silly. I don't like getting the giggles on the docket. So we cannot send invites to telephone numbers. One of the reasons that district court is requiring that everybody appear by video unless unable to do so. There's more functionality. I like being able to see the attorneys. I think when everyone can see each other, it just goes more smoothly. We, however, have a ton of defendants that just don't have that capability, and we've been doing a lot of mixed hearings where we have the attorneys and the courts on video, and then we call somebody from court, or they can also get in by telephone. So you can do it either way, where they're waiting in the waiting room by telephone. They can call in ahead of time, or we can also call them from court as necessary so that they don't have to wait. And sometimes we have a number on file, we have a defendant, and we give them a call, and it's surprising how often folks will call even when they're not necessarily expecting it. One of the other things to be aware of is phone calls from Zoom will show as, I think it's a New York number right now, so that's another thing to advise clients about and just be aware of, is that it might look funny getting a call from court from within a Zoom hearing. But because we cannot send an invite to a telephone number, that's why it's really helpful if folks gather emails for their clients so we can give them that direct invite from the court. So once you log into that hearing, you're going to be put directly into a waiting room. The court decides who comes in and out of that waiting room. So depending on the court and the type of proceeding, they might have everyone come in, or they might leave folks out in that waiting room and just take one proceeding at a time. And as Judge Veljacic mentioned, it is a really good record doing it through Zoom, even by telephone. All of that goes directly into our recording equipment instead of it, for example, being through telephone where it's just a microphone picking up what's coming through a speakerphone on a telephone. We are anticipating by next week that we are going to be live streaming. So for example, when I am in court holding hearings, that will go to its own YouTube channel so that we can observe open courts. Folks are able to not have to appear in the courthouse. They can watch live proceedings. They will not remain on our website or otherwise be recordable. I mean, people can always use a phone to record just like they do now in court, but there'll be information that this is not to be recorded. They can still request a record afterwards, just like we would now, but that's something that we're anticipating having up and running hopefully by next week. So once you're in that hearing, and we talked about breakout rooms and how effective those have really been, we can do it in a couple different ways. We can also do it with the jail booth. So if you're representing somebody on a criminal matter and they're in custody, we can still have you go talk to them as part of the hearing, and then bring you back into the courtroom. Another reason why we require the video is you have more functionality. If you're in a breakout room by telephone or a jail booth, you can't bring yourself back into that hearing, only the judge can. And so it's helpful to have at least one of the parties by video, because then once they pop back in, and so then they would show again in my hearing, I know that the attorney's done talking to their client, so I can close that breakout room, and then that would bring their client back in by telephone or the jail booth, depending on how they're appearing, or they can just come back in by video. Those breakout rooms are confidential. The judge does have the ability to join that breakout room, but no one else would be able to do that. And so it is quiet, it's not recorded, it's totally separate from what it is that the court's doing at the time. And again, that can be a mix of video and phone to do those breakout rooms. As we discussed, we have the ability to screen share documents. The judge can mute and unmute folks as necessary. One of the things, just so you're aware, we will be actually live in the courtroom with our judicial assistant, and in Superior Court also the clerk, because we are on the record and our recording requires us to go through the actual courtroom setting. So we won't be appearing remotely, just in case anyone was curious about that. I know there's some jurisdictions where judges are actually appearing remotely. We will be physically in our courtrooms. District Court's also working on the exhibit issue and document sharing. We've looked at Dropbox. Frankly, I think it's a little hard to use, especially if we're talking about, for us, like a lot of pro se folks, like on the anti-harassment docket or small claims. So we're looking into some other options, including potentially public portals to be able to access documents for a particular case number. So we will certainly keep updating folks and putting that on our website as we go through that. And then we have a lot of other controls that the other participants won't have. So when you're hosting a Zoom meeting, you get control over the breakout rooms, whether or not people can screen share, those mute, unmute functions, bringing people into the waiting room, those sorts of things. So really it should be fairly easy for us to kind of regulate the docket in that way.
That's very helpful. In fact, I think that a lot of those mechanics that you've mentioned are going to be the same types of procedures that Superior Court's going to be using if they haven't already. So I did want to just remind participants that this Zoom CLE is being recorded as well and will be available on YouTube. So if you didn't catch everything that you heard today, or you know some people that didn't know it, spread the word. It will be available to rewatch through the Clark County Bar Association for free. So that's great. But Judge Parcher, maybe you could also share with the participants today, you know, some do's and don'ts that maybe you've learned from being on the bench with Zoom.
Okay. I do just want to mention too, because I kind of forgot, and Commissioner Ellis had mentioned it. We're actually emailing court documents to litigants as well. So the same concept, we're really trying to limit the amount of touches. And so when we do have the occasional person in the courtroom, we're not requiring them to use the stylus to sign. We're not handing documents back and forth. Really, we have the capability of doing things electronically. So just be aware of how you can do that going into this, for example. So the do's and don'ts, I know it got really nice being able to work from home remotely in pajamas. I'm requiring people, I get up every day and get dressed for work. I'm requiring people appear by video, and I'm expecting that it be just as if you were in court. I just think our litigants, everything else is kind of crazy and haywire. It's difficult enough appearing over video. I think we really need to show litigants the respect and the decorum that they deserve in the courtroom. I'm expecting folks, you know, our local court rules that state that attorneys shall be dressed in a manner consistent with the current generally prevailing and accepted business attire, including coats and ties for men and dresses, skirts, jackets, and slacks for women. I mean, the upside is if you're sitting down, you only have to do half of it. So, I mean, I'm not going to make you stand up and prove to me that you're fully dressed for court. However, we need to lend that decorum to court proceedings. It is a hearing where, preference is always to have those nuances and that one-on-one feel, but this is what we're going to be doing for some time. And the expectation is that attorneys dress appropriately. We had a discussion about not allowing virtual backgrounds because we were concerned about potentially what some defendants could come up with. However, I think that there's, attorneys that are appearing, folks that are appearing, there might be privacy issues, there might be safety issues, if you had a victim appearing in a domestic violence case. So virtual backgrounds are okay as long as they're either plain or they're a professional setting. I'm going to direct your attention to Ms. Sheldrick because the county has put together, and you might have to talk so it changes.
Yes. Hi, everyone. I'm going to demonstrate a couple of virtual backgrounds here. These virtual backgrounds are going to be available on the district and Superior Court websites for practitioners, and maybe we can also get it over to the Bar Association. So here's one, obviously the courthouse. Here's another one, sort of your standard bookshelf looking lawyerly office. We'll try to get maybe one other one, but the idea, I think, Judge Parcher, you can tell me if you agree, is that these would be the preferred backgrounds just because it puts sort of everybody on the same playing field.
Yes, and I think that issues come up too. We have folks, and sometimes people are going to be in their cars taking calls. We have folks who are living, who knows where. And so it is a level playing field. I mean, ultimately, it's just kind of like with dress. The point is that we're hearing arguments. We're not distracted by whatever a background might be or by what someone's wearing. So, advise your clients and then just think about it in terms of you. Be extremely careful if you are working from home, who's in the background, what animals may be around, and just be really cognizant that we want this to appear as professional as possible and look like it's court. It is court. So, I mean, I need to reiterate that. It is court and it should be reflected. So during the hearing, I'll just, again, I cannot stress the being cognizant of your muting enough. I would rather have to say, hey, Ms. Sheldrick, you're on mute, please unmute yourself, than have to, listen to her, chatting, sharing personal information and asking her to mute herself. So, when in doubt, put yourself on mute until it's time for you to speak. Objections, Judge Veljacic and I talked about this. I mean, there's no real rule, but if you're appearing by video and your hand's up, we're going to notice. And so, we can come to you immediately or at least know that there's something else that you're trying to say. Again, I think that's another important reason. Although you'll notice with virtual backgrounds, if you move really fast, things disappear. So just try to, again, be cognizant of how things work in this kind of weird setting. Really, you need to speak clearly. You need to look directly at the camera. Shouldn't be talking with your hands as much as I am, and you should really try to be still. Again, just try not to distract or make the virtual background look weird while you're talking. I think that Ms. Spencer, so I drug Marina Spencer into this because she's with Vancouver Defenders, and one of the things I can't stress enough, practice with your friends, do a practice hearing, just familiarize yourself with it. Marina got drug into me practicing from my courtroom, so she's been kind of doing this the longest, and so she might be able to kind of share just things that have helped in terms of telling her clients or kind of what to expect a little bit too.
Okay, great. Well, with that, how about we go to Marina? Thanks for joining us, Marina. Maybe you could give some tips for the attorneys on appearing via Zoom for Courtroom. Also, I just wanted to remind the participants out there that we're coming up on a few more minutes of the presentation. I'm sure we'll go a little bit longer if we need to. So if you have questions, use that chat function to send them in before we end this CLE. So Marina, take it from here, please.
Thank you. Thank you, everyone. I just wanted to demonstrate the importance of staying on mute. I had a phone call earlier. Good thing I was on mute. Just wanted to be a good example. It is really important that people not hear confidential information and stuff like that. When it comes to advising your clients about what this is going to be like, My experience has been most people don't have Zoom. I don't have Zoom. I don't know what that is. So I've been conducting most of my hearings with them appearing over the phone. I've had maybe one or two appear over the Zoom video. Just important to let them know that it is a courtroom. We can see you. Don't let your clients know. Don't be drinking. Don't be smoking. Don't do something that they wouldn't do in a courtroom. Don't even be eating. Have the appropriate attire on. I mean, most of my clients don't have a suit and jacket, but a t-shirt works great. So just make sure that they're clothed and that they're aware that they can be seen. It's also important to advise them not to screen their calls if they are going to appear over the phone. It's, you know, in the beginning stages of this, there was a lot of frustration with, okay, I've talked to them, they're expecting the phone call, they don't pick up because they don't know that number. Advise them, it's a New York area code. Between this time and this time, do not screen your calls, please pick up. And once they're on the line, it goes pretty smoothly. I've been advising my clients not to do any arguing, not to say more than they need to, not to talk about the case. We don't want our clients to do that in a courtroom anyway when it's not the actual trial or when they're not prompted to do that. The advantage that we have in the courtroom is that we can tell them to shut up, that we can go over there and say, hey, stop talking. That is a little more difficult with this setting. They don't have you there as their attorney to advise you when to zip it. So that's something important to advise them of. Just don't say anything that's important about the case. This is procedural. Most of these things have been just very procedural, or guilty pleas, which you should really go over with them first. Make sure that they understand everything. I've gotten some confusion about how the signature is going to work. Explain that a judge will acknowledge their signature over the phone on the record, just so they're aware of that. As an attorney, I have discovered don't say more than you need to during a Zoom hearing. I'm treating it sort of like I have an interpreter there all the time. I don't know about you guys, but when I have an interpreter case, I try and keep my sentences shorter and my arguments more concise. I mean, I know that I can be long-winded sometimes. A Zoom hearing where you're just getting forward court dates is just not the place to do that. So have more thought out, more concise arguments. Sometimes there's a little bit of feedback with the courtroom. So there can sometimes be an echo. So you just want to keep it short and concise and effective as possible. It's very easy to zone out on a Zoom call, on a Zoom hearing. I would suggest, I know that everything is being done over email and over the phone. I would advise, and I need to take my own advice, try and put your phone away if you're doing something, if you're doing a change of plea, if you have to make an argument over Zoom, because it is so easy to just not pay attention. I mean, sometimes that even happens in court. I know that's happened to me, but it's even easier to zone out when you're doing a Zoom hearing. So just try and be more aware, more cognizant of where you are, and just like Judge Parcher said, it is an actual courtroom. So don't do anything that you wouldn't do in court. As Judge Parcher said, no eating, no drinking, no proper court attire. Do practice hearings. I think those are all my tips. I think I've gone over everything unless I've missed something.
Well, that's good. Emily, I was just gonna share really quick. So sorry about the inappropriate one. That one cracks me up as we're all getting used to being on Zoom all the time. But this is a document that you can share with your clients. Superior Court, I think, has something similar on their website, but just virtual hearing information with how to contact the court with good contact information, contact your attorney, and just some tips on how to get in. So feel free to go to our website. and look for some of that information to share. And Emily, I have a question from Ms. Darko. If you want me to answer first, or Judge Veljacic, do you have?
Sure, you go for it.
Go
Okay.
ahead.
So someone is asking, yes, or someone asked, will a judge be present in Kamas-Washougal Court beginning next Thursday? And I apologize, I should have looked ahead of time. You'll have to ask that department. We have been handling the Kamas-Washougal Thursday dockets virtually. I want to say we may be starting in person out there next week, still trying to handle as much as we can virtually, but they have it set up so that we can social distance and things are marked and measured out. And so just contact the assigned, or just contact Kamas-Washougal Court and ask Lindsay out there, but they have been working to get that set up. Which is kind of a reminder going forward, just like everything else, we know that we're going to have folks that need to appear in person for whatever reason. Either they don't have the capability or something else is going on. So as much as we can plan on continuing to do virtually in June and July and even August, I've been advising people, hey, I know we're setting this for whatever probation violation docket August. I might still want you virtually so we can kind of save that spots for those folks that really need to be in person. So Kamas-Washougal will be the same way. I think they're going to try to do a mix of virtual, but potentially, you know, folks who have been summoned in for arraignments that don't have that ability or we weren't able to get a hold of to ask them if we can do it virtually might be in person. And then the other question was how will walk-in warrants be handled and will warrants be issued? So under the Supreme Court order, anybody who is ordered to appear for an in-person hearing, we're not issuing warrants on. We're anticipating maybe some additional Supreme Court guidance in the next week or so with a hearing as some courts are starting to open around the state depending on their phase or kind of expand to more in-person hearings. We as a bench right now don't have a firm answer on that. My position at least is I don't think that we're going to be issuing warrants until we have the ability to deal with walk-in warrants. So that means until we kind of have our system set up where they can contact, say, hey, I missed court, how do I get in? That we won't be issuing, but we're having at least one, if not two judges meetings every week. And so that's something coming up now that we're starting to summons people. Our new summons actually says your matter will be heard virtually and give them the information about how to participate that way. So at that point, we'd be issuing warrants, but right now we have not been issuing warrants. And then if a client appearing by phone, can they call number on Zoom invite or does court have to call them? No, they can enter the meeting and they would be put in the waiting room just like anyone else. Usually what I do at the beginning of my docket is anyone where it's just showing as a phone number, I'll kind of bring them in. I'll say, who do I have here? This is Judge Parcher. They'll give me your name and then I can rename them. So then it's showing up for everyone who that participant is by telephone since they're not appearing by video. Or the court can call them directly. And so sometimes when we have dockets where we have, example, Marina might have 6 people on, we would schedule them all in one block. And some might come in by phone. It's actually a little bit easier at that point when we have the same set of attorneys and different defendants to just call them so that they're not waiting that whole time in case we get behind. I just have concerns about folks having to be on hold for too long on their phone. Great.
Okay, thank you, Judge Parcher. Judge Veljacic, did you get some questions?
I did.
Okay.
The first is, does court not plan to return to normal operations with live hearings and trials after the shelter-in-place orders are lifted? And so certainly we would like to. I will say, if this all went away very soon, there would still be some aspects that we have discovered, some aspects of our current operations that we have discovered that we will keep. Particularly our probate docket. I happen to be a fan of how we're handling it now, where you know, it's always been that the bulk of the work is done in preparation and then the hearings are quite short. We've been doing that in chambers. And when there's something that requires a hearing, that's cited on as a special set. That may stick around. Other aspects like hearing, deciding summary judgment motions without oral argument. I did that during the first few weeks of the pandemic. I may continue to do that on some cases where I think that's appropriate. But in terms of looking forward, one of our planning assumptions is we're not going to be back to what normal was for some time. In some cases, we're talking 9 months, a year. There's differing opinions on that among my colleagues and I about how long that's going to take. But we certainly need to move through our phases as the governor has outlined. And yes, if we can return to some normal and keep some efficiencies, we will. We also have to be realistic that this may rebound in the fall, especially if the kids go back to school. That may impact the infection rate. Will we have a vaccine? I don't know. So we'll follow the governor's lead and the Supreme Court's lead, but so I don't know that I have an answer for that.
What about the question regarding the citations of the hearings and the show cause? But before you get to that, I don't know if you have that question specifically.
I may. I have another one though.
So I just want to remind the participants one more time, make sure you chat to Lisa your name and your bar number so you can get CLE credits. I know we have a lot of people on the call and you'll want to get your CLE credits. So make sure you do that before you sign off. Did you get the question about when citing a hearing, what should we put on the citation notice of hearing for the location of the hearing? I would say that's the same as anything,
Right.
But do you have
I
to
agree.
include that it's somehow going to be a Zoom hearing? And then what about for orders to show cause requiring personal appearances?
We've been, this relates somewhat to Judge Parcher, what she said. We have on our summonses, we're hoping to roll this out in the next few days where we will be giving information to self-represented litigants on criminal cases to call indigent defense to get an attorney. We've really been relying on attorneys to convey the Zoom appearance aspect to their attorneys, to give that information to them, to their clients rather. So when you're citing on, you put it in front of the judge. The citation's not going to be different. I don't think a show cause is going to be different, but I do think if you're trying to get someone to appear, you should be responsible for communicating to them the mode of appearance. With that said, again, our courts are open. We don't want a flood of people because we don't want to manage that environment and have them all wait in a crowded hallway. We want to avoid that. Typically, there are not a lot of show cause orders issued. And so we can, I believe, manage a small number. Contact the assigned department at this point. And, it would help if you conveyed out the Zoom information. I don't have a formal pronouncement from the entire bench on that, but that would be my approach. I think I've answered another question here too that asks whether a low-income client who does not have working phone or internet access can have another option to appear. Come to court. The preference is remote appearance, but again, we can't just shut down court. The Supreme Court hasn't given us that option, and we have a strong open courts doctrine rooted in both state and federal constitutions. So there was another question. There's a few more. Ms. Sheldrick, are you seeing those?
There's the guardianship docket question. How will that be handled? Will that continue to be handled the same way? Documents to the assigned judge electronically instead of the probate judge?
Yes. So far, we're meeting tomorrow afternoon to issue another general order. Some of our orders are expiring on the 1st. So there's more information coming. Judge Collier actually happens to be on a very small committee with the state Chief Justice about some of these operational issues. And so we've been able to get some good information through him. But yes, to answer that question, there's one here, any anticipated date when civil jury trials will resume in Superior Court? I don't have a date. What I will say is currently we will have a significant backlog of criminal cases, which will take priority. So I cannot predict how that will work and when we will have a chance to do civil trials. Our hope is that we can continue to be responsive and serve those who are coming before the court for resolution of their matters. Emily?
So what about Commissioner Ellis? Was there anything else that you got that you would like to answer?
I did receive one question. The question is, how do you know if the docket is full? The same way that you know that you knew before, the clerk's office will send out an email closing the commissioner dockets. So that's how you know. There is a list. I was on it as an attorney. If you're not on that list, I would suggest you either email Becca or the clerk's office to get on that list.
Okay, any other last thoughts before we close out CLE?
I just want to say, you know, we're all in this together. It's going to be clunky and awkward. I accidentally ended an entire hearing with a bunch of participants that had to get back on the other day. So be patient with us. We'll be patient with you. And actually, I have a docket right now I need to get to. So I'm going to into another Zoom hearing right now. So thank you, everyone, for participating.
Thank you, Judge Parcher.
Great, thank you so much. Again, just one more reminder, this is available on YouTube for the Clark County Bar Association's YouTube channel. So unless anyone else has anything else to say, I think we will end this meeting, but thanks everyone for joining us.
Thank you.
Thank you.